will honor that. Jeff.
Thanks, Kayleigh. You mentioned that the court decision today was a win. It didn't sound from the president's tweets this morning that he viewed it that way. Has his thinking on it changed as he's had more time to digest?
No, the president was making a general point about deference on the principle of absolute immunity, which is the posture that the president took in court. He believes there should have been more deference there. Justice Alito, citing the Harvard Law Review, made a very good point that constitutionally speaking, the president never sleeps. The president must be ready at a moment's notice to do whatever it takes to preserve, protect, and defend the Constitution and the American people. And we wish there would have been more deference to that point of view. But it is a big win, as Justice Kavanaugh noted, that all 9 justices said this needs to be remanded back to the lower court, and that in fact the attorney, Cy Vance, had not established his ability to secure access to those records. Instead, further proceedings are required.
Giving the opportunity for the U.S. Attorney in New York to look at those documents is no doubt not something the president is happy about. I'm wondering, in general, if after this ruling and the ruling on DACA, the ruling on LGBT rights, the ruling on the census, whether the president regrets at all his criticism of judges, in particular Justice Roberts, Chief Justice Roberts.
No, I think what the president, what has been underscored to him after all of these rulings is that, we need more conservative justices on the court. And that's something he's very strong about. It prompted him to say he'll release a list of more conservative justices he wants on the court. So I think that's been the big takeaway, not particularly with regard to this ruling, but with the previous ones that you mentioned.
There are conservative judges on the court now. It's a 5-4.
Yes, and then there was a 9-0 unanimous decision that this needed to be remanded, and there was a roadmap, as I noted, a roadmap set forward on how to proceed in the lower court, and there were several arguments proposed that the president could make in lower court. Yes, Kate.
I've got 2 questions for you. One, on these rulings today, the Supreme Court is rejecting this assertion from the president that he is immune to investigation while he's in office. Does he agree with that he is not immune?
Well, where the president stands is he still maintains his initial position, and he agrees with Justice Thomas in the dissent, who said the demands on the president's time and the importance of his tasks are extraordinary, and the office of the president cannot be delegated to subordinates. A subpoena imposes both demands on the president's limited time and a burden, and he went on to describe that position. So he agrees with the dissent. He agrees with the dissent by Justice Thomas. So he takes issue with the point that the majority made on absolute immunity, but nevertheless, I would underscore the victory here as Cy Vance, the attorney, was not given what he wanted, which was access to the records.
He still thinks immunity is he's immune to investigation.
The president still stands beside the posture that he made. He accepts any Supreme Court opinion as the law of the land, but nevertheless doesn't change his viewpoint. He can disagree with the opinion, but he certainly will follow it.
And on coronavirus, my second question on coronavirus, I'll be quick. You're saying that you don't want these CDC guidelines to be one-size-fits-all, overly prescriptive about how these schools reopen. So why is the administration making it one-size-fits-all that they all need to reopen fully and at the same time?
Because there's a way to safely do it, and there's a lot at stake. I mentioned the 67,000 pediatricians represented by the American Academy of Pediatrics who say it's imperative schools reopen. That was underscored by another 1,500 United Kingdom pediatricians. The costs are high when, your network, CNN, is reporting about child abuse. I mentioned the study yesterday. It was a good piece by CNN that in Massachusetts alone, reports of alleged child abuse dropped almost 55% because when kids are not in school, a lot of times we don't catch that abuse. The costs are too high to keep schools shut down. They can safely reopen. Even the American Academy of Pediatrics believes that, and the president's going to stand on the side of the child, always.
And no one is disagreeing with that about child abuse, but I'm saying, how can you say you're not going to tell all the schools how to reopen, but you're going to tell them all when to reopen?
There are 47 guidelines issued by the states. There's local guidelines that have been put in place. This can be done safely. It can be done well. In the American Academy of Pediatrics, I've pointed out a lot of what they've put out their own set of guidelines. There's a number of guidelines floating out there, and we believe there's a way to safely do this, and the child will always come first in this administration. Yes.
Thank you, Kayleigh. A logical follow-up to Caitlin's first line of questioning, though, is if the president still believes he has absolute immunity, it makes him sound as though he thinks he's above the law while he's president of the United States, at least.
It's almost as if folks don't understand a legal term of art. Absolute immunity is a legal term of art, and I can go and describe that, and maybe I can best describe that by quoting Alexander Hamilton, who was referenced in the Thomas opinion. And Alexander Hamilton really created the posture and the outlook that laid the foundation for the notion of absolute immunity. And it was this: energy in the executive is a leading character in the definition of good government. It is essential to the protection of the community against foreign attacks. It is not less essential to the steady administration of the laws, to the protection of property against those irregular and high-handed combinations which sometimes interrupt the ordinary course of justice, to the security of liberty against the enterprises and assaults of ambition, of faction, and of anarchy. A feeble executive implies a feeble execution of the government. And the point he was making is that the executive is imbued with many constitutional authorities, many responsibilities to protect this nation from threats, foreign and domestic, and he must be able to operate unencumbered. That's where the proposition of absolute immunity comes from, and that is what the administration was defending in court. And we are pleased by the 9-0 opinion to send this back to the lower court, though we're not pleased by the absolute immunity component.
Perhaps,
yes.
Could you